My name is Martijn Schoonewille. I'm only moderating, so I'm definitely not one of those specialists. Those are here next to me. My name is, like I said, Martijn Schoonewille. I'm an attorney at Loyens Loeff. I have two lives, basically, and my wife knows about it. It's, on the one hand, financial supervision and capital markets, and secondly, I'm part of the innovation committee within Loyens Loeff. As just was asked during the previous panel, indeed also the legal industry is looking on what transformations business are going through, not only for our clients but also for ourselves. And what we see, and that's why it so very much resonates with what the Odyssey Open Innovation Program is about, is that we see basically four realities. And that is not something we have invented ourselves, that is also what business schools bring. Basically the four realities are: it's all about client satisfaction. B, clients are moving targets. 3, business ecosystems create value, and platforms boost co-creation. And I think that is really what it's about in our view. If you look at the collaborations and the solutions, how to take it to the next level, in that case you also need to have a sound collaboration. And in order to do that, today we're going to discuss that from different perspectives. Allow me to introduce my colleagues, because we have an international panel, and we would even have a more international panel if one of our colleagues yesterday, who was driving to The Hague, didn't have a car crash, literally, so it's quite a journey. So two of our colleagues stepped in, being Nina and Yannick, who you already know from the previous panel. Nina is our definitely GDPR expert. Yannick brings knowledge from the IP perspective. My fellow partner, Marc, who is tech enthusiast by heart, but also very fond of the competition and regulatory, so he will share his expertise in that. Perhaps also tell something about your book for digital competition. And Olivier, who took the effort to come from our Luxembourg office, has very much insights both on the IP side of things, but also litigation perspective, risk management. Now, I start with you, Olivier, because we work with quite a few different types of new joint ventures, collaborations. Recently, we had the opportunity to work on a technology-driven kind of solution. Can you tell me something about it?
Absolutely. Thank you, Martin. I think I could take this opportunity to present a very practical use case, something that we're currently advising on, and that brings together considerations of distributed ledger technologies and personal data exchange. Actually, of personal data is at the very core of the implementation of this DLT-based project. And it also brings together considerations of a regulatory nature, because the target clients are going to be financial institutions, and also of competition law. So technically, when you do have such a project, and that it can be a viable one, you have to keep in mind that all of those questions will keep on coming back. And it's not necessarily because you have been very successful at a hackathon that the relationship with the legal partner basically stops. You have had some very preliminary initial advice on what you should watch for, but then at the moment of implementation, all of those questions come back. So this practical use case that we're currently working on arises out of a collaboration between a university and a non-profit entity. And the idea was for the university to develop the technology, and then for the non-profit to try to understand the target markets, had all the contacts with the financial institutions to try together to develop a product that would be commercially viable and for them to service basically the industry. So what they're trying to do here, and what will probably happen at the end, is a KYC, so know your customer, DLT-based technology tool. You're basically looking at one problem, and this problem is the one of onboarding clients when you're a bank To some extent, even us, as lawyers, in law firms, we also have a very, let's say, a rather lengthy onboarding process. We have to ask for documents from our clients. It can be for a bank, it can be a proof of residence, it can be a passport, it can be some tax forms. All of those information belong to the clients of those entities, of those banks. So they are personal information. I think there is absolutely no doubt about this. Your passport is as personal information as it can potentially get. The problem is that every time you're going to be banking with a new financial institution, whether you're getting a loan to get a house or whether you're opening a checking account, you're always going to go through the same process, which is a little bit annoying for us, for clients like us, but also for the banks themselves. Why? Because those very documents are available elsewhere, right, with other banks. So this was basically the idea. Why doesn't this nonprofit and the university join resources together to try to come up with a product that would allow those banks to share the customers' personal information together? They would make use of distributed ledger technologies, as Nina put it earlier, as minimum as possible. Most of the personal information of the clients would be stored off-chain. So the way that it works in practice is you bank with your usual financial institution, you exchange information, your documents, your passports directly through the web's interface of this particular bank. So this bank is going to store it off-chain in its own database. Another bank that is part of this consortium of financial institutions is going to know that this personal information that has been encrypted and hashed on the blockchain. In this case, it was Ethereum that was used. A Hyperledger could also be used for this purpose. So another bank would see that this information is available, would request access to it. So request for access to the information is going to be stored on the smart contract on the chain. The permission that is going to be granted when all of the members of the consortium, namely here the banks, are going to vote on the granting of the access, this is also going to be stored on the chain, right? And then the exchange of information will take place with the consent of the clients. So in a nutshell, this is the project. Don't hesitate. If you have any questions, please do intervene, because this brings up all sorts of elements. You may also have some technical questions and some expertise in this domain. I would very appreciate hearing. Already,
and we didn't even start yet. So
I'm glad.
Don't use the moderator.
I'm glad I got you to stay in the room, because you were about to leave, huh?
I was about to leave, so
all
thank
right.
you for pulling me back in. What if we take this in the context of not banks, but customers? So for instance, a customer would grant access to a particular set of data that is off-chain.
Mm-hmm.
Then storing the identifier for that person would also be considered personal data, right? So is it then also possible to store you granting this access on-chain?
The granting of the access, I guess yes. You can store it on chain. The question is, from a GDPR compliance perspective, and let's say EU data protection perspective, you want to be able to put up all the safeguards that are technically possible and available to you at this moment in time. If you're going to be storing anything on-chain that relates to off-chain data, chances are, because of the append-only nature of the distributed ledger you're using, you're always going to have a little something that will remain on-chain no matter what you do.
Exactly.
A solution would be, and this is technically disruptive, I admit very highly disruptive, but in this case, all the members of the consortium are the validating nodes of this ledger.
That triggers quite a bit of questions. If everyone is validating nodes, because then you get always the legal concepts of is everyone then the controller? How would you look at that?
Well, there's a lot of discussion about who the controller is on the blockchain, because so basically the European Unions or some European institution part of the European Union issued guidance on this, and basically they're not in agreement who is the controller, because if you're working with a lot of validating nodes, it would not almost make sense to have all of them being the controller. If they're consumers, however, they might fall out of scope of GDPR, which would make the whole thing more convenient from that perspective, but you would still have to appoint a GDPR controller. So there's no consensus on that question whatsoever.
No, true. Hey, because we now immediately dive into GDPR as it is, a lot of data driven. That's the solution. What it's all about. What makes me curious was, how did the parties come together? Can you maybe tell something about that? Was it because ultimately, when we're looking around, we're talking about really business ecosystems, trying to come up with a solution. And just during the break, I already had a chat about, we just established that IP rests with the teams, challenge owners brought in the challenge. What's next? How do you go with IP? And where this gears towards, Yannick, and I think it's also for you to, I was wondering, if we talk about IP, right, it's with the team, we talk about ecosystem solutions. At the same time, we are still geared towards the old-fashioned way of thinking, right? That the solution rests with one institution, with a specific team, with a specific member, with the challenge owner. And it's for you, Yannick, maybe to shed your lights on, but also for Olivier, maybe first, I was curious on the solution we are currently working on. How did they consider this, or what is their common goal? What is their purpose?
With respect to ownership of IP, it's 50-50.
Okay.
They have been working on this for 2 to 3 years for now, before coming to us to advise them on the implementation and the viability of the project. But they had already gotten together some time ago, because they have different expertise in very different domains. I mean, one of them had, let's say, the experience and the expertise dealing with financial institutions, and the other one, university, had the technical knowledge, the R&D resources necessary to kind of put this together, and had all of the creative ideas from the tech perspective, because you have to work around what the data protection authorities are giving to you. And some of them are going to give you, let's say, the French Data Protection Authority, the CNIL said that the destruction of the private key was actually one of the measures that you could be taking in order to render the data as anonymous as possible. So the threshold under the GDPR for something anonymous is extremely high. You may not reach it. Yet you should aim towards achieving this. So then you have to look at, for example, the UK Data Protection Authorities told you that perhaps what you could do is try to put the data that remains on the chain beyond use. What does that mean? Well, this is for the technicians to some extent to try to find out. So this is how the parties really got together, and there is no chance that one could have done it without the assistance of the other.
And ultimately, they're going to provide services to banks, right?
This is going to be a first stage. Yeah. We start with banks, and then other types of financial institutions, and then perhaps mutual funds, hedge funds. So the whole of Luxembourg.
And then the world. Well, to add to this, before the break or during the break, I briefly discussed an ecosystem with a few of the persons in the room here, and they were talking about the difficulties with bringing on partners to the ecosystem and making sure that all IP is still shared throughout the ecosystem. And that is another thing you need to be aware of, that if you bring on partners, you need to identify who is going to make which IP rights and what should we do with those IP rights. Should they be fed back into the ecosystem and be available to all participating partners? Or should one of the partners become the owner of the IP and then bring a license to all other partners in the ecosystem? And these are all valid questions, and depending on the ecosystem and the setup of the ecosystems, there is no right answer. It has to be tailor-made to the specific ecosystem.
No, because I think that is something which is quite intriguing. Because Marc, we recently also worked on a similar kind of project. Because if we where parties from, let's say, one silo try to cooperate together, really come up with an ecosystem solution. And one way or the other, we're still geared towards discussions about where does IP sit. The previous panel, it was very much about that discussion. Whereas perhaps, and that is also something we are still need to get used to, is if you really want to share it, how do we achieve that? And really make that that possible. And I think that is also difficult because it frequently relates to sharing of data, Mark, and I think that whether it's in your solution for KYC, ultimately it's about sharing of data. Banks very much need to do so in order to open it up. Other ecosystems, whether the logistic case we could refer it to, where parties from a logistic chain, all different types of parties want to cooperate. It's also about sharing information. Is it something you can do freely, Mark?
Yeah, very good question, Martijn. No, I think like what is really important when you are working with an ecosystem, you have to consider who are the partners, and if they are competitors, then you have to be aware on whether or not you can share data. So in the example of the banks, if all banks will come together and they will start sharing information and data with each other, then you need to ask yourself the question, is that compliant with competition law or not? That doesn't mean that you cannot execute your solution like with the GDPR, but you have to make certain safeguards to make sure that you're still compliant. And if you look at ecosystems, you have the ecosystems which use data and basically come up with a new solution by using the data. And then of course is the question, if you are, as competitors, are going to provide the data which is necessary, whether or not you can do that in an individual manner, or that you should do that more on a high level aggregated form, or pursuant to which you cannot basically reconstruct the behavior of a certain competitor. And I think that that's very important. So one is the information gathering for the platform and using that again, and otherwise is it just competitors sitting together and discussing commercial sensitive information with each other.
Yeah. And so, but that also because previously the focus has been very much on personal data, I think for very good reasons. But this it goes basically far wider than this, right? It's not only about personal data; it's about business sensitive data.
Yeah, definitely. So like if you look, for example, at the Facebook case, I don't know, most of you probably have heard of it in Germany. Basically, Facebook has been not fined, but at least the competition authority there said you have a dominant position, and because you have a dominant position, you can say, well, we're going to use your personal data, and on the basis of the terms and condition, which was an infringement of the GDPR, and basically the competition authority said, because you are so dominant, you can make this infringement, and therefore I find this a violation of competition law. So basically you see them also both intertwined. So I think like if you look at tech solutions, basically you can look at it from a consumer perspective, from a GDPR perspective, so privacy perspective, and from a competition law perspective. And of course you also have the more ethical component. But if you look now on how issues are being dealt with, especially if you look at the super dominant companies, then basically the four themes that I just mentioned will be looked at and to see whether or not there can be a solution or very important values that we all have can be safeguarded.
Yeah. Can you, Olivier, can you say something about it? How these challenges were, or perhaps still, are being tackled in the KYC solution?
With respect to competition law, in this case, when the objective is to bring together the greatest possible number of financial institutions in one given country, you're definitely looking at having to put up safeguards, because if you do not, the competition authorities are going to be onto you. In this particular case, you will have interactions between all of the members of this consortium, because we don't know how many financial institutions are going to end up joining. But of course, the objective would be for dozens and dozens of those potential clients to join in and then become a validating node and participate and run the smart contract and then become very active and share information, because at this point it's a volumes game. So that means that they're going to be interacting between each other. They're going to be speaking. They're going to be meeting, at the very least for shareholders meetings. which means that you basically have to make sure that all of those entities which are competitors are going to keep the meeting in line with what was scheduled. You have to ensure that they're going to be talking about what is relevant. Clear agendas, I would say, is one of the safeguards that you definitely want to put in place. You need to make sure that it's agreed beforehand, that it's circulated between the members of the consortiums that will be present, and that you're going to stick to this particular agenda. Which leads to another point and another safeguard, which is minutes of the meetings. When you attend such a meeting, you want to make sure that someone is going to record what is being said, and that these are going to be the official minutes of the meetings that took place, and that all of the members, all of the participants in the meeting are not going to be taking separate notes.
Because, Olivier, to interrupt, basically what you're saying is you should first have a proper discussion on what would we like to achieve, so that the intents and what is the job to be done are very much aligned, right?
Absolutely.
And then stick to the plan.
And you stick to the plan, and potentially have legal counsel, either in-house or external, as the case may be, to join the meeting. And should one of those participants go on a different direction that perhaps could be a little bit risky in a competition law perspective, perhaps this legal counsel would allow to either you put an end to this conversation, bring it back on topic. I mean, there's different. I understand that you're currently involved in such meetings. Perhaps you can give.
Yeah, no, that's exactly how it goes. Like the logistics case that Martijn just mentioned, their competitors are sitting together, sharing information, discussing their goals, and then it's very important for them to make sure that they stay compliant with competition law. And then, for example, you also have the awareness statement, basically a short notion that everybody wants to be compliant with competition law. That also mostly helps. But also a lawyer in-house or external can be present to make sure that it stays in line. So if they reach the boundaries, that you can say, well, this may be a subject that we should not discuss, and maybe discuss it first with, for example, me, and then discuss it publicly, and that helps in these kinds of meetings. And basically with all professional companies where competitors sit together, these type of measures will be taken and make sure that you're compliant. Because like the counterfactual is, if you don't do that, and for example, even if it's not on purpose, you enter into a cartel, you could like be severely fined. In the Netherlands, it can be 80% of your group turnover. So that's tremendously, that could lead to eventually even to a bankruptcy. So like it's something which may not be in top of mind, and definitely not after winning the hackathon, of course. But still, like these are very important things, and that's also why it's being taught at all business schools, for example. Not that it's the main driver, because the main driver is of course you being successful in the ideas that you have. But I think one of the messages that you also should take from maybe today is that you also need to make sure that from the design you have to be proactive and think about these things, and you're also responsible for what happens.
Yeah, and because I think one of the takeaways say, okay, we first should have a good, clear goal on where we're going, what is our common approach, and then when you're entering into the corporation, it's about really thinking out loud, okay, what is the type of corporation we're going to have, and also talk about IP, right, to put it into motions. Can you maybe say something about, if you really want to achieve that ecosystem kind of solution, how can you go about that?
Well, we touched upon this in the first panel discussion. You can always make sure that all IP that is created in the operation of the ecosystem is licensed under an open source license to all third parties. So everyone can use all intellectual property. However, if the third party using the open source intellectual property then makes something different, you might want to also have that new intellectual property being fed back into the ecosystem. That is slightly difficult with an open source license. Mm-hmm. So either you need to tweak the open source license, or you need to have an additional agreement granting access to the intellectual property of the ecosystem, and then have an additional obligation that all intellectual property that is created using the intellectual property of the ecosystem is then being put back into the ecosystem. So you have to this continuous loop of development building on the ecosystem and then giving back.
And in practice, is that indeed how people are geared? Is that what they would like to do?
Of course, we have this old saying in the Netherlands: the one who pays is the one who decides. With intellectual property, if you pay for something, be it development or anything else, you would like to have the intellectual property. So it's counterintuitive to invest in something and then just give it to anyone else. It's difficult. True,
and basically it requires a different type of mindset. I think that's what we are discussing here. But that is something to have a good chat about, also with challenge owners, and not to really, if you really want to bring that together, and you really want to also bring competitors together, to have that type of conversation, and that really is a different way of collaboration. In the more sphere of, let's say, sharing lessons, right? Let's say, what are some? Could each one of you, let's say, share perhaps some useful lessons on contractual arrangements or things that really people should bring together? If you talk about how can we accelerate our solution afterwards, from a disclosure perspective, from contractual perspective, lessons learned to bring in. Technical safeguards, you already mentioned a few, Olivier, on just making sure that from day one it's already slotted in. Maybe from your KYC case to some useful points to share.
So with respect to technical safeguards, one thing to keep in mind is that what is state of the art today might not be tomorrow. You encrypt as much as you can. Use state of the art hashing, encryption techniques at the moment. Keep them up to date. Of course, what is state of the art today, tomorrow might not be. So it actually requires you to keep on doing this technical work on a regular basis, because this is going to assist you in compliance, in achieving compliance with the data protection laws. And you have guidance, and as time passes we have more and more guidance. The UK, as I mentioned earlier, the UK Data Protection Authority already issued some guidance with respect to putting data beyond use and perhaps how to do so, or at least what would amount to doing so. The French authority did the same thing. The EU Parliament looked into this as well and reached the conclusion that you have to render the data as anonymous as possible. Where it's not possible, use pseudonymization techniques. One of them would be zero knowledge proofs, and then went into more details as to what kind of zero knowledge proofs would allow you to achieve the greatest possible anonymity. So these are some of the technical safeguards to put in place. And then it's going to be up to the technicians, up to the engineers to be creative. What will help is going to be to keep control of the ledger. To the extent that you can use a private and permissioned ledger, you should. It allows you to keep control. It allows you, as the case may be, should it hit the fan, that you can basically remove the entire chain. Extremely disruptive, perhaps, but it is one of the possibilities. And then you have to look at other ways. For example, if you want to give effect to one's request for a rectification of a data, or even erasure, it's extremely difficult insofar as distributed ledger technology is involved because of the append-only nature of this ledger. You can add to it, but you cannot necessarily subtract to it. So the greatest control you're going to have over the ledger, the better off you will be. You could consider, for example, rehashing, taking out a block and rehashing. Again, extremely disruptive because it would require all of the nodes to sort of re-add all of the prior blocks. So yes, it would be extremely disruptive, yet it remains a possibility. Another way would be to amend your information. You could add what is called under the GDPR a supplementary statement, right? So you add another block. In your previous block, you said you were single. You're now happily married. right? Your status changes, your information changes, your documents need to be updated. Some of those documents are hashed on the chain, right? So some of the information there has to be modified. If you add another block, it will not replace the old existing block, but it will update your information. So these are ways to remain constantly creative.
That doesn't destroy the reference to the earlier block, so that
it doesn't.
So if you just append the data,
it doesn't.
And you know, any views from your perspective on that approach? It's a bit.
Yeah, maybe you want to finish your comment first, and then I'll respond.
No, I think if it was right, but if you consider this in the terms of giving access, so giving out a mandate to access data, for instance, does it work the same way? So if you take back the mandate to access data, is that enough in order to prevent GDPR conflicts?
Well, you have to give effect to the data subject's requests for erasure, and this is the right to be forgotten. This is what it's called. Here and with respect to this project, you can give effect to it in both ways. And then you also have reasons why you should not necessarily give effect to it right now. Mm-hmm. Right? So those two levels on which you have to give effect would be with respect to the actual documents, right? The passports, the proofs of residence. These are stored off-chain in the databases of the respecting financial institutions. So the customer is going to go to one bank and say, you have my information, I give it to you, I now want it back. It is going to be up to the bank, if it wants to be GDPR compliant, to give effect to this. Now, this is quite easy. Of course, consent is something that you have to be able to give and revoke as easily. So it becomes up to each of those banks to have a web interface that is going to be easy to use and that is going to allow the data subjects to pull out that information quickly. So this is going to be on the bank's level, off-chain level. And then with respect to the on-chain level, then you basically have to get as creative as you can.
Do you agree?
Well, I think that Olivier touched upon a lot of practical challenges, like we discussed earlier under GDPR, and I think I just wanted to add two more things to that. So, like I previously mentioned, GDPR at the core is the accountability. So, I mean, I think we can all agree that the way GDPR is currently structured, is not a one-on-one fit on a blockchain solution. Because it's from a different time. It was developed with the background of internet upcoming, and not with distributed ledger technology. So that is one big thing to consider. And as we've seen, there's a lot of authorities who are really looking into pragmatic approaches on how data protection can be implemented with these new technologies. So that is something to keep in mind. There is no general, if you do this, then your blockchain will be compliant, but compliance will be achieved or nearly achieved on a case-by-case basis. And that really requires parties that are working with this to really carefully think about what they're doing, but also if you're looking at maybe scaling up at some point, will what I will be doing in a scale-up phase, will that still be the same as what I intended to do in the beginning? Will I be using the data for the same purposes and in the same way? And if that's not the case, then you should, again, start reconsidering. And although GDPR is, well, data protection compliance is an ongoing thing which should be taken into account, you really need to, every time you take a new step, you need to look back. What was my starting point? What was my intention? What was my purpose? What am I doing? And can that purpose be aligned with what was my initial goal? And I think if you add that to what Olivier said, I think you have a really good shot at being, well, taking into account all requirements of GDPR. Yeah.
By the way, is that unique? That you, because obviously we're now talking about GDPR in the sense that we should take that into account in design. Maybe to you, Mark, is that unique to GDPR only? Because to me it seems that whether it's the legal framework in general or tax considerations in general, that those are those are easier or cheaper to take into consideration if you do that from day one? Or can you say, no, it's only GDPR which you should take into account for design, but for the rest?
No, like if I take it back to competition law, almost all authorities have already said in use cases that you are responsible from the beginning. So, for example, in the UK there was a case where an algorithm was basically forming a cartel. In Germany you had, like with the air, there was an for the flight tickets, there was also an algorithm which was setting the prices. When one of the companies went bankrupt, the prices increased, like to like basically 5 times the price that they were before. And in all cases, they said, okay, the defense was basically, it's not us, it's being the algorithm that's doing this. And then, of course, the authority said, no, you are responsible for the algorithm, you are using it, and that was a little bit what was in the discussion one as well, that you can say, well, okay, you are using it, and you also have the developer. And then you have to see who's responsible, and what is very interesting until now is that the user has been addressed and has been seen responsible from a competition law perspective. Well, if you look at the case law, then I think that you should start with the software developer. And that's basically facilitating. And if you are instructed to do so, then you can be both liable, in my opinion. But until now, you basically see that the people that are using it are being held liable. And even Commissioner Verstager has also said, like, no matter the algorithm, there's always somebody responsible. So I think, and also like the discussion that we had with the cars, who's responsible, is that the software driving the car, is that the Google Maps that's being used, is that the person that bought it, and how it's being used. That are all very difficult questions that that we need to deal with in the future. But I think that if I should give one lesson, is that basically you are responsible yourself. You are you need to be aware of the risk that brings about, and just be aware of that. And it should never disrupt the creative thinking, but you should be like highly creative and then reflect. If that's the system how you work, and I mean reflect before you act, of course, because so not after the crash with the car, then you should reflect. But if that happens, you should of course also reflect. But you should also reflect in the beginning. Yeah. So like I think that's a key takeaway, and I don't think that matters whether or not it's from tax law perspective, whether it's for GDPR, whether it's for competition law. I think, but you guys, and that's the cool thing where you're sitting, is like you meant to be creative, and it's very good that you're here, and basically that already means that you're aware of that there are certain risks that you should take into consideration. But like, please be creative, and that the legal part not be in the way of your creative thinking, because that's basically where we come in. Like, we are here to help you, and that's what it says, I think, here on the slogan, like, help you stay ahead. Like, we are here to help you make it work. So if you look at the Luxembourg case, if you look at the logistics case, if you look at the other cases that we're working on, basically we're trying to help you succeed in implementing your ideas. And the only thing that we're here for is to help you with the challenges that brings to properly construct it. And sometimes that means it's a little amendment, but it's better to make the little amendment and have your idea implemented, basically legally, correctly, and that's the only thing. So that will be my key takeaway. So please don't worry about it too much. Just do your job and we'll do ours.
True. No, thanks, Mark. And I fully agree, and I'm also looking at time and a little bit aware of time as well, because we have indeed hopefully still a few other questions to be addressed.
So based on your experience, right? Like today we see like a lot of startups leveraging technologies like blockchain and distributed technologies to build solution and take it to the market. So based on what you see, at what stage do these startups face challenge, and what type of challenge do they really face when they want to take something to production from prototype phase to?
it's for me. It's a little bit like first you have to have your idea, basically see whether or not you can make it work, and before you implement it, that would at least be from my perspective. Before you implement it, you have to have these checks. But first you have to see whether or not you can make your idea work, and basically think about it. And if there are challenges, then maybe you will already know it. But basically what you do is, like, if you would give us your pitch and say, this is what I'm doing, I'm using this kind of data from these persons or from this entities, and I'm using it this way to produce this, and I think we can perfectly advise on what to do. So that would be my perspective.
I think one of the challenges and one of the benefits we nowadays have is if you think of a challenge, it's not only one jurisdiction only. In the previous panel was already mentioned from an international law perspective. I'm also thinking about considerations if you really want to scale it. And through the internet, before you know it, if you put something down in English on a website and offer it through the world, before you know it, you're offering in jurisdictions which you did not even were aware of. So I really think, and it's important that Mark also stressed, it's not about business prevention team, it's about making it possible, right? I think we see benefit and merit in, let's say, getting a continuous relationship in making that involvement. That doesn't mean that you need lawyers all the time. You also need to have flexibility in order to operate. But at least the flexibility should be there to continue to work together. I think that is where we come in. I think at earlier stage, then you can together jointly identify if you need more attention or less attention. Sometimes we see parties who have gone already through some motions and then made huge investments as well, or as a result thereof, corporations fail because they weren't aware of the different considerations. Or shout.
I can shout. So basically, one question that I have is that a lot of these open protocols, right? When you were speaking a little bit, thank you. You were speaking a little bit about mechanism design and being permissionless, or whether it's going to be permissioned. But my question is, if you're interacting with a open source protocol like Ethereum or EOS, you need a native coin in order to interact with them, right? So if you're building on Ethereum, then ETH needs to be converted into your ERC if you're using a token, for instance. Right now, regulatory bodies don't really classify them as securities, but if your goal, and if the goal of the Odyssey ecosystem is to create new business use cases and new token models, is there a risk in the future that the core protocols or ledgers that are supporting these new solutions will begin to be scrutinized? And if they are scrutinized, does that mean that you will be basically screwed because the underlying protocol that you're building upon is now illegal?
Shall I take that one? This very much resonates with the regulatory environment, right? So in Q3 2020, European Commission is about to come up with new papers on crypto assets, and regulatory research is continuing to happen. This is not new. This is for over the last four and a half years that this are looking into. And indeed, the qualification of certain cryptos to use a framing is indeed on the radar. I think what you need to distinct is, on the one hand, your solution and to what extent you need the coins to make it work, and on the other hand, to what extent are there perhaps parties involved in that system who requires regulation. Thanks. Always pleasant. I think Mike, I'm not particularly concerned about, let's say, that solutions will become illegal. It's about, let's say, having a solution which is agile enough that you can cooperate then with regulated exchanges, with regulated intermediaries, as we now do with your typical asset managers and banks, payment service provider, etc. The fact that we have decided that payment services like your WorldPay, your Adyen, your Payvisions are regulated doesn't mean that you can't use your money anymore. I think we need to round up, but if there are any pending questions, happy to take them. We are here. Well, oh, you have one more question.
I have one question in regards to safeguarding the consortium itself, because in the example of the banks, I think it's more of a private blockchain, but still the data is shared. And if you adhere to the rules of a blockchain, people can leave the blockchain and still have the ledger. If that is the case, then that means that one of your competitors, as it's no longer your partner, has the information up till that time. So how does this work with accountability? I mean, when you're still in the consortium, of course you have to adhere to the GDPR rules and you can safeguard it. But when one of the partners leaves,
you still
then
have to adhere with the rules of GDPR and accountability, yeah.
Yeah, meaning that you as the consortium, the old consortium, the original consortium, you are accountable for what someone that's no longer part of your consortium is doing.
But I guess it also really depends on the purpose, because in this example, the banks would only be granted access if there's a reason to be granted access. And if you look at the KYC requirements, that is a legal obligation of a bank to comply with. So even if you were then to leave, you would have the data maybe, so the other data on the ledger which you would not be entitled to, but in principle what you have is something you need to have. But it's a very valid question. I think in a lot of ecosystems this could be a really big challenge.
Yeah, because when you do a private blockchain, you can implement some rules and regulations for yourself. Yeah. When you enter the public blockchain, not so much.
Yeah, so that is also, I think Olivier mentioned it before, but I think the current view of the data protection authorities is you need to have a permission blockchain under data protection laws, basically. But then again, if you get creative with how you work with the data on that, you might get into the gray area, which we're all striving for, I think.
Yeah. And in all honesty, in all the solutions, collaborations we see, they are more geared towards private blockchains. So the it also has to deal with adoption. Change cycles are not that quick as we all want them to be, but it's there is where we indeed see opportunities.
Yeah, but the problem with gray areas is that it can go both ways.
Yeah, but if we look at the approaches which are currently, so if we look at the guidance which is being issued by the authorities, by the European Commission, by the research centers, they're all trying to be pragmatic with what they have. And I think that, and at least there's a lot of discussion going on in academics, but I mean, in general, the law needs to catch up with what is happening. And there's a really big discussion going on in the field of academics, so from all different kinds of expertise, how new technology should be addressed in a broader sense, so not only from a legal perspective, but also from the ethical or practical approach.
Thank you.
Thanks. That brings us to the end. I think a few takeaways. It's really about, let's say, making things possible. Probably having that proper discussion. Technology can make a lot of things possible, but have a good discussion on what you would like to achieve within the team, but also with your challenge partners. Set that common goal. What is your job to be done, and how are we going to achieve it? Then please step a little bit back and have a good discussion about how to structure that collaboration. It's good to take the different approaches into account, and then what you already do during the hackathon, but also thereafter, is look at the tax and legal validation of your solution, and don't do it only once. It's like probably most of the teams will work, iterate, pivot perhaps, change, and then continue again. And I think that is ultimately where joint cooperation, whether it's your in-house legal, external counsel, or friends and family who can help you out, please do that and make use of the knowledge which is out there. That's the good thing about the hackathon this year, with even more Jedis than the years before. I'm sure you can make some good connections. This year we will be there again with an international team from people from Luxembourg, Switzerland, Belgium, the Netherlands to help out where possible. So we very much look forward to it. Thanks so much.